Today we have with us Mr. Gopal Sankaranarayanan. As a name, he does not need any introduction, and all of us as students have grown up reading all of his articles on various interpretations, intricacies of the court case, and all of that. He has argued numerous landmark judgments in the past and the present, and he has been part of numerous current cases in which he was also appreciated by the Supreme Court bench. So before further ado, in this discussion, we'll be talking about the Section 377 judgment, a 493 pages judgment by a 5-judge bench, which has decriminalized the gay relations, lesbian relations, all of that by deleting certain portions in Section 377. So let's begin with this.
So, sir, the first question is if you could shed some light on the background of the case, how this case evolved over time, 2009, 2013, and then 2018.
Yeah, I think a large part of the people who worked closely on this case actually came from my own college, National School in Bangalore. I remember that it was quite a progressive issue in the late 90s, in September 97, if I recall correctly, when the first ever seminar on gay rights on a university campus was conducted at the National School. There was a lot of resistance there. I remember students who were working in the mess committee, specifically objecting because you had delegates from the LGBTQ community coming and staying there, and objecting to them staying, objecting to them drinking water from the same filters and stuff like that. It was really, really absurd. But the people who put that seminar together, many of them eventually came to work at the core of these issues at various points of time. To a very strong constitutional and legal way. Subsequently, there were multiple groups who had taken issue with 377 interpretation, how people were being harassed, etc. So, two of those were NAS Foundation, founded by Anjali Gopal, and Voices Against 377, which is a loose conglomeration of lawyers, writers, journalists, many other people who were voicing against it. And they had moved petitions in the Delhi High Court. That eventually came to be decided nearly 8 years ago by a bench of Chief Justice A.P. Shah and Justice Muralidhar in the Delhi High Court. Their interpretation was on the basis of Article 21 and Article 14, pointing out that penile non-vaginal intercourse, PNV as defined it, was something that the law seemed to frown upon, and that it was not a valid kind of classification to make. And subsequently, I think people were very happy because the High Court had laid down a judgment which seemed bold and independent. That was an excellent judgment, very well written, and both judges needed credit for it. Subsequently, it came up by way of SLP in the Supreme Court. And the funny thing there was the kind of stand that was taken by the people who had made that law, or deemed to make that law, which is the Government of India. So, while it was in 1860 legislation, etc., the Government of India in the High Court, through the Additional Solicitor General then, P.P. Mahalwal, had taken a very strong stand, saying that 377 has to be given full control and flow and frowned upon LGBT relationships, etc. But strangely, they didn't challenge the judgment when it came, reading down the provision that was essentially theirs. And there were many fringe elements, extreme religious groups, etc., who felt that it was anti-religious, immoral. Some people felt that it was against health conscience, etc. And they find SSB, Suresh Kaushal was one of them. The government decided to take a kind of neutral stand before the Supreme Court. And so when it finally came to be decided, this possibly answers one of the questions that you had asked me earlier about how is it that the bench came to decide that viewpoints changed over the years and stuff like that. Of course, I think from the 1950s till now, we would have moved slightly towards a more tolerant, liberal manner of thought, but I wouldn't like to believe that this case had actually come up in the mid-50s. The consequence of constitutional interpretation may have been different. It's just that at that time, people were quite constrained by social orthodoxy to come out and boldly fight for it, or to get lawyers engaged. who would fight for it. Because I know many of the people involved in these fights tried to engage top lawyers, even in the Supreme Court, and many of the lawyers didn't show that kind of commitment. They would demur and say, "We help you from outside, don't want to really be seen our way." So when it came before these judges, remember the Justice Singhvi, who chaired the head of the bench, had only recently cancelled the 2G licenses and been very, very strong in monitoring CBI investigations into that. So many people believe, he doesn't shrink from passing tough judgments. Popular opinion at that point of time, including that of the government of India, was that, we can allow this dilution of 377 to happen. So eventually what happened is, I believe that those who argued before that bench, I think, began to realize that this is not going well for them, but they couldn't do anything about it because the matter was already being heard. And eventually the decision was, if you can look at it that way, one which is against popular opinion. And Justice Singhvi delivered on that again, reversing what I thought was a very well-reasoned judgment in the High Court. Justice Mukhopadhyay added his own views to that, but it was a judgment which took up progress of fundamental rights chapter back several years, because it showed a very narrow-minded, restrictive view, and it particularly showed a complete lack of constitutional understanding, which was encapsulated in one passage, where it said that because it is a minuscule number of people who are affected by this law, we possibly shouldn't trouble ourselves too much in understand that. And that is important. That passage should never have come. There is another passage where he rejects completely the applicability of foreign jurisprudence to the law, despite us having used foreign jurisprudence for many of the progressive judgments we've had over dozens of years. So it was a regressive judgment. Now, reviews were filed, curative petitions were filed. If I'm not wrong, even the government of India filed a curative petition. So it was shocking the government should actually do that, because all they had to do was go back and pass an amendment in 5 minutes like they do for every other law. They barely debated. They push whatever they want to through. But they did not want to be seen as taking a stand here, because both the Congress government then and the BJP government subsequently did not want to alienate those aspects of their electorate who would be sympathetic to the retention of 377. So they didn't want to come out and show that in Parliament and try to convince the people to pass the bill. So they decided to let the court go ahead and do it, and then shrug their shoulders when their electorate came to them and said, "Sorry, Supreme Court did it." They've been doing it in many cases. This is just one example. So the curatives were pending, and they referred to larger benches, and for nearly 4 years it was pending. Now, while it was pending, the reference in the Aadhaar case to 9 judges came up before a bench of 5 judges at that point, headed by Chief Justice Kehar. That was on a Tuesday. And Chief Justice Kehar overnight said, since we're looking at the correctness of 2 judgments, Karak Singh and MP Sharma, which are of 6 judges and 8 judges respectively, why should we waste our time in 5 judges hearing? Let's hear it in 9 judges. Obviously, everybody agreed, and I think the petitioners were a little hesitant, because last time a matter had been referred to 9 judges, it had taken years for it actually to be constituted. So eventually, we were very surprised. He said, "We'll sit tomorrow." So on Wednesday, we suddenly find 9 judges, and full and complete credit to Chief Justice Kehar for constituting a bench of people who had such grasp of constitutional law and understanding. Both Justice Nariman and Justice Chandrachud had both practiced as constitutional lawyers as well. One had been Solicitor General, the other had been Additional Solicitor General. Justice Chalameshwar's control and understanding of constitutional law was exemplary. Justice Kaul had come as Chief Justice of Madras, and his knowledge and grasp was also fantastic. So I think Chief Justice Kehar picked a bunch of people who were very, very good on understanding constitutional law principles. It's not that it was a pre-decided issue that, look, we want this to go in one way. he realized that these are people who have the wherewithal to do this. So he comes to the bench overnight, and then the hearing started, and he was very disciplined in having it over just 10 days or even less, maybe 7, 8 days hearings, which is very unusual for a bench that big. And while he was having those hearings, I think on the third day, Justice Chandrachud, I remember, because I was also arguing there in the extreme right, he leaned forward and he said, while determining Article 21 and its scope, he said, look, there could be many factors in it. He mentioned choice of place to reside, choice of food, choice of clothing. He said sexual choice, and then he went on. I think for many of us who were sitting there, when he mentioned sexual choice, it made you realize for the first time from a judge of the Supreme Court an explicit statement that 377 is not okay, right? And it gave you hope that here's somebody who is one of the most valuable persons on the bench saying that 377, essentially, sexual choice is a part of Article 21. Now, what I found funny personally is that quite a few people who argued for the petition, I was arguing for interveners supporting the other act, but at the same time saying that privacy should be there in the Constitution. So, quite a few of the people who argued for the petitioners in Tuxtami were also arguing for the petitioners in the 377 case that came subsequently. So I was expecting that they would pick up on this and they would make arguments about sexual choice, etc. Because when 9 judges are going to lay down Article 21, whatever they lay down will be law for everything else. And then we waited and waited. The petitioners finished all their arguments, not one person talked about sexual choice. So when the respondents started arguing, after the Attorney General and one other counsel finished, I stood up and I made submissions on other issues about the legalities of Sharma and Khan. And then I said, when you're talking about sexual choice, one point I want to make, when we're talking about Article 21, one point I want to make is that the government had taken the stand that there are only 6 or 7 petitions for privacy. And if there are only 6 or 7 people, they are talking about their own right to privacy. So they can't, in public interest, talk about everybody else's 1 billion people's right to privacy. So I said, that kind of argument is extremely harmful, but it's not unprecedented because let me show you the most abhorrent passage in the history of our Constitution. And I showed them this passage from the Kaushal, where they said, you're such a minuscule number. I said, that's the same argument that's being taken by the government of India here. That you are so minuscule, why should we care about you? I said, if being minuscule is a reason for you to say rights are not available to you, then you might not adopt the Constitution in the dustbin. Because the Constitution is to protect the minorities, the marginalized and the small from the big, from those who can use the Constitution to terrorize you, from the majorities in each case. So I said you need to overrule this idea of thought. Separately, I said that Article 21 should definitely include privacy, sexual choice, etc. But that idea had anyway come from Justice Chandrachud. So eventually, when the judgment came, I found 2 things remarkable. One, that the Chief Justice of India had not written a judgment. Now, it's unusual when you have 9 judges, a sense of vanity prevails among a Chief Justice saying, I made this bench, I'll write judgment. He wrote nothing. He just adopted what was written by Justice Chandrachud, and again, all of them were in agreement on privacy, on its scope, and they specifically struck down those passages from Kaushal, but said, anyway, the main issue is pending before a larger bench, so we'll wait for that then. But went ahead and said that sexual choice is part of Article 21. So, for many of us, and it was written about a lot then, with that happening, nothing survived in this case. 377 was effectively gone or read down as far as the LGBTQ community and as far as adult consensual sexual acts were concerned with the Puttaswamy judgment. Now, of course, we were waiting after that for when the curative will get listed. In the meanwhile, some celebrities who belong to the LGBTQ community filed this petition in the Supreme Court and said that, look, earlier you've been hearing petitions by groups or those acting on behalf of the LGBTQ community. Here are individuals who are personally affected, and we would like to take them. So that's how Johar's case came up along with all the others. And when that was listed, I mean, that came up before Chief Justice Mishra, and Chief Justice Mishra's kind of mind is substantially different from, say, Justice Singhvi's mindset. And he believed that, look, it's a penal law and we need to have a constitutional bench and we can decide quickly. Yes, I think the bench, once again, you could say, could have been constituted as liberal, etc. But it was by and large the core members of the Swami bench, Justice Nariman and Justice Chandrachud, who were on it and who have really, penned some of its most influential passages. The only problem that I had was it was not necessary for it to be that lengthy. I mean, it was a simple matter, it's a simple implementation of a 9th Puruswami judgment that was binding and saying, in view of sexual choice being part of Article 21, there's no question. And they should have ended it in like, say, 50 days. I think Justice Malhotra wrote a fantastic judgment, which was brief and pithy, and also made that long wanted point that you need to, that history needs to apologize for what had taken place. I think that's a logical consequence of everything that happened thus far. So it's an excellent judgment, and it's very important because for me, while the 377 issue per se of decriminalization was sorted by Puruswamy, it's encouraging to see the signs of what could come, because the direction has been, the signposts are there from both Justice Nariman and Justice Chandrachud's judgment of what further rights are available to those communities. Because I think Justice Nariman makes that point very clearly, saying that this is not about decriminalization. This is about their rights which are available to them. And so, if it's about the rights of the community, it will include all civil rights like marriage and adoption and things like that. So, I think it's encouraging, but I think it has to be seen in its perspective.
So you talked about how celebrities came out. So can it be said that that like it was due to societal impact? Societal impact was also one of the factors in shaping this judgment, like because more and more people were coming out. So and until 2013, like it was from an organization. The 2009 judgment was on NAS.
Oh well, if Justice Mishra had just constituted a curative bench in Kaushal, I think the consequence would have been the same. Yeah, I don't think that would have changed because, of course, it helped that there was so much more being written about it, etc. But I remember when the 2013, 2010, 11, whenever the High Court judgment came out, it was there on front pages, colored pages, 5-6 pages devoted to the one High Court judgment. So there was a lot of press and media and all that. I don't think in the last 10 years it has changed hugely. It was very, very positive even 10 years ago. But I think one got fortunate with the kind of judges who were hearing the case. And it was good that you had a larger, broad-based bench, because when you have 5 judges passing a judgment like this, it's not going to be easy to reverse or in any way erode it. Because they've all spoken in multiple voices, 4 judgments speaking for 5 of them, which is very comprehensive.
So what about the government stance? Like they filed an affidavit stating that it's upon the court to decide what to do.
No, that's completely wrong. It's not upon the courts to decide. It was a pre-constitutional law. They have had at least 2 law commission reports detailing all the various laws from before the constitution, which needed to be revised, which were retrograde, which should have been removed, amended, deleted. They have made at least 40 to 50 amendments to the Indian Penal Code in the last 70 years. So nothing prevented them from replacing 377 with a provision which limited itself to non-consensual acts against children, animals, etc. as they wanted it to be. They allowed it to continue, and then they didn't want to be seen as taking a strong stand. So let's not have the government taking credit for this. They have nothing to do with this. So if the court can give their permission to pass this.
So what will be the future course? Future course in two senses. First, the marriage laws, the inheritance laws. People will be allowed to marry, all of them.
I anticipate that there will be many more people who will be filing petitions now. And I hope they will be well composed petitions, genuine ones, to further these interests, which the direction for which has been given in the Johor judgment of obtaining their civil rights. I would hope that it's not PILs again. I hope it would be people who genuinely want to adopt or want to marry, and it's been rejected by a registrar somewhere, who will move court and say, look, this is a right that's available to me. I'm a citizen. I have to have these rights as much as a heterosexual couple will have. So we'll possibly see that, and it's not only marriage. It would be any other aspects of saying opening a joint account in a bank, for example, or virtually many other things where they strictly look at only spouse. With the Nalsa judgment, we saw that governments across the country have been directed to change all the documentation formats to include the third gender. We'll have to have that changing here as well, with reference to instead of wife, they have to say spouse and things like that, so that you will encompass all these communities within it.
So in furtherance to that, what will happen to the people, one, who are languishing in jails, and second, who on the pretext of Section 377 have been arraigned before the courts throughout India? So will those people will be let go of the cases by withdrawn by the government of India? What will happen to them?
See, those statistics are not being made available. I don't know what those statistics are with reference to them. In my view, it would be that, if I'm not wrong, because I haven't read the 493 pages thoroughly, I understand, I think only Justice Malhotra has said that this judgment would be prospective in nature and save existing prosecutions. I don't think the others have said that.
It's not prospective in the sense.
No, it would be declaratory. So once the law is struck down, everybody will have to be released, because you don't have a law on the dates that you are going to go ahead, which will permit them to be continued in prison. It's an Article 21 violation. So if it's an Article 21 violation, you have to have a due process in which you are restraining this person and curtailing their liberties. If that law doesn't exist, then you can't continue to curtail their liberty. So, in my view, if there is anybody in jail, they should be released immediately. Which is partly why the publicity aspect was highlighted in the judgment.
So the last question is in regard to the judgment written by Justice Deepak Mishra. So the Chief Justice speaking for himself and Justice Khanwilkar talks about two important doctrines: doctrine of progressive realization of rights and doctrine of non-retrogression. So if you could tell us about the relationship between them and what do they exactly mean?
You want me to give you a simple answer? I can't tell you, because I don't have a clue. The reason is that, many of these judgments should be actually limited to just sticking to the principles on which they are based. To conjure up new principles and make them fit would not be appropriate, because this realization of rights is a question that means that earlier it didn't exist, it exists now. I'm uncomfortable with such an interpretation, because in my view, even if there was one gay in this country on the morning of 27th January 1951, then one gay had the right to move the court and say 377 violates my right. One person, alright? But to say that you will realize the rights of the community over a period of time means it wasn't there for a while and now it's slowly become. I don't think that is an appropriate process to subject our constitution to. These are rights which are always there. It's just that when the question arises, when you interpret the constitution, you say, yeah, okay, this is a right which is there. Right?
So, like Justice Neumann talks about public sensitization. In that sense, there are two aspects. One, you sensitize the general public, but the general public says, what about the army? The army had gone loose about all the formats, like how this cannot be permitted in the army. So will this right apply to the army men, the person serving in the armed forces, or is it just for us, like the civilians?
No, I mean, there's no question. It applies across the board to every citizen of this country. All right. Now, the problem is, unlike in the United States, we don't have a Civil Rights Act. Okay. So, for example, in a company, if they say that we don't want LGBTQ members applying to us for jobs, it's patently discriminatory. But we don't have a law which says that it's patently discriminatory. We have a fundamental rights chapter which is against the state. We don't have any rights which are against private entities, enterprises, individuals, etc. With reference to the army, one could equally argue that army is state. So if the army discriminates against me on that ground, I can file a petition and say, I'm sorry, this is a fundamental right that I have of employment. You can't say that because of my sexual choice that I should be excluded from being in the army. The US Army, which is supposed to be one of the most powerful standing armies in the world, have LGBTQ members in it comfortably. There was resistance early, but they overcame that. There doesn't appear to be any rational link between a person who goes to battle and his sexual choice. In my view, I don't see any link at all with that.
Thank you, sir.
You're welcome.